Mr. LIEbowitz advised that he had missed the conference because of a death in the family, which was an unexpected urgent matter to which he had to attend. This letter is not responsive to my instruction. Mr. LIEbowitz was to document who passed away, when the person passed away, and when Mr. LIEbowitz was notified. The reason I requested documentation is that there is reason to believe Mr. LIEbowitz is not being candid. When someone dies, there is documentation, including a death certificate and almost always an obituary, and nowadays one's phone usually contains evidence of what one was told and when. Oh, he's so screwed.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
This is a remarkable update in the entire LIEbowitz copyright trolling debacle. In our last video, in our last episode, LIEbowitz was fighting the moniker, naming him copyright troll. He thought that that was enough to get the judge recused from the case, that particular case. Well, in a different case, a judge has been fighting him for documentation of something. LIEbowitz seems to have missed a court hearing that I think LIEbowitz asked for, and instead of eating crow while the crow is young and tender, or surely you will eat it when it's old and tough, as the saying goes, instead of eating crow, he has doubled down, and then tripled down, and then quadrupled down, and then quintupled down, and then is it sextupled down, and then... He's gone several steps through this. I'm looking at about 20 different documents here, him going back and forth with the court. But the court has written a 7-page summary, and I know not everybody wants to watch 30 minutes of these videos, so a 7-page summary should be pretty dramatic. I think you guys will find this one really fun to read, so I present to you Judge Siebel's order to show cause why LIEbowitz should not be sanctioned even further for not presenting the death certificate of his recently deceased grandfather. This is in the United States District Court for the Southern District of New York. This is the Jason Berger versus Imagina Consulting case. You don't need to remember the case, but there's a whole bunch of different cases that LIEbowitz represents in. So the judge writes, on April 5th, 2019, defendant filed a letter with the court requesting a discovery conference. So that means LIEbowitz filed the letter with the court requesting the discovery conference. That same day, I granted defendant's request and scheduled a discovery conference for April 12th, 2019 at 11 a.m. I also ordered plaintiff to respond to defendant's letter by April 9th, which plaintiff did. On April 12th, the court held the discovery conference, but plaintiff's counsel, Richard LIEbowitz, did not appear and did not call or email the court or defendant's counsel to explain his absence. That same day, I ordered plaintiff to show cause in writing on or before April 17th, 2019, why he failed to appear for the conference and why he should not be required to pay defendant's attorney's fees for the time expended to appear at the conference. The court also rescheduled the conference for April 18th, 2019. By letter, dated April 15th, 2019, Mr. LIEbowitz advised that he had missed the conference because of a death in the family, which was an unexpected urgent matter to which he had to attend. He also said he would be out of the office on April 18th and asked to appear by phone at the rescheduled discovery conference. The conference was held by phone on April 18th. Mr. LIEbowitz represented that the death in the family occurred on the morning of April 12th and apologized for not letting defendant's counsel and the court know. During the conference, issues were discussed that reflected negatively on plaintiff's counsel's credibility. For example, plaintiff had answered interrogatories saying his damages calculation had relied on contracts, invoices, and licensing agreements, but when defendant requested those documents, plaintiff said he could not produce them without a protective order. After defendant agreed to a protective order and the court signed it, Plaintiff still produced nothing, despite twice promising to do so. Further, defendant's counsel represented that Mr. LIEbowitz had told defendant's counsel that he could not comply because he was out of the country due to an emergency, when in reality he was at a trade show in Europe trying to drum up business. At that point, concerned about Mr. LIEbowitz's credibility and the possibility that he was trying to increase costs for defendant's counsel, I determined that I could not merely accept Mr. LIEbowitz's representation that he missed the April 12th conference because of a death in the family, and directed that, among other things, by May 1st, Mr. LIEbowitz provide evidence or documentation regarding who died, when, and how he was notified. I also permitted defendant's counsel to submit his billing records related to the discovery dispute by May 1st, with Mr. LIEbowitz having until May 15th to submit opposition to defendant's application that plaintiff cover those fees. I also expressed concern over how plaintiff's claim of $5,000 in damages could possibly have been made in good faith. By letter, dated May 1st, 2019, Mr. LIEbowitz represented that his grandfather had unexpectedly died on April 12th, 2019, and that Mr. LIEbowitz was needed to assist with certain customs for which arrangements had to be made in advance of the Sabbath. That same day, I endorsed the letter as follows. This letter is not responsive to my instruction. Mr. LIEbowitz was to document who passed away, when the person passed away, and when Mr. LIEbowitz was notified. The reason I requested documentation is that there is reason to believe Mr. LIEbowitz is not being candid, so a letter from him does not advance the ball. When someone dies, there is documentation, including a death certificate and almost always an obituary, and nowadays one's phone usually contains evidence of what one was told and when. Mr. LIEbowitz may have until May 3rd to supplement this letter. On May 3rd, plaintiff filed a notice of settlement. On May 7th, I advised as follows. I'm glad the parties have resolved the case, and I presume the issue of plaintiff's counsel's expenses for the April 12th conference. But there remains one open issue, Mr. LIEbowitz's failure to document the death in the family that he says caused him to miss the conference. He was supposed to address that issue by May 3rd, but I will give him until May 9th. Even if defendant has been made whole, I still need to satisfy myself that there is no need for disciplinary or other inquiry.
From my experience in the past 3 years of watching your videos, Leonard.
Yes.
Is it true to say that when the court starts saying I, rather than using the monikers that they use, this
Good observation.
is serious business? Like, the court is like shedding all of the formalities and is saying, this is what happened and this is what I'm going to do now.
Yeah.
Like, it's a really big deal.
Yeah. Courts don't usually write in the first person, so that's a very good thing to notice. On May 9th, Mr. LIEbowitz filed a declaration in which he recertified that the statements in his April 15th and May 1st letters were true. And he stated that he believed that his declaration discharged his obligations to the court. On May 13th, I responded that Mr. LIEbowitz's May 9th declaration did not resolve the matter because, given the issues surrounding his credibility and failure to provide any information or documentation regarding his grandfather's death, Mr. LIEbowitz's reiteration could not sufficiently discharge his obligations to the court. I, therefore, issued an order to show cause requiring Mr. LIEbowitz to provide documentation or other evidence apart from his own word that demonstrated that a death in the family had occurred that prevented him from attending the April 12th conference and timely notifying the court and defendant's counsel of his inability to attend. Rather than comply with the court's order to provide the above documentation, on May 16th, Mr. LIEbowitz again submitted a declaration reiterating his belief that his statements contained in the April 15th, May 1st, and May 9th letters were sufficient to discharge his obligations in response to the court's order to show cause. On July 26th, I ordered Mr. LIEbowitz, under pain of contempt, to provide a copy of his grandfather's death certificate so as to support his claim that he could not attend the April 12th conference, nor provide timely notice to the court or opposing counsel as a result of his grandfather's death. Now, keep in mind, this is July 26th. This is over 2 months later. Was it April, May, June? July? It's like 4 months later, three months later, I can do math, 3 months later, and he still doesn't have a death certificate to provide, I think we're smelling a rat here. In response, Mr. LIEbowitz submitted another declaration on August 12th, stating that he believed that his previous letters sufficed to fulfill his obligations to the court in spite of the fact that I explicitly requested documentation other than his say-so, and that he should not be required to submit his grandfather's death certificate because it is a personal matter. As I noted in my August 19th response to Mr. LIEbowitz's letter, however, although the death of a family member is certainly a personal matter, questions regarding his candor before the court are professional in nature. I reassured Mr. LIEbowitz that if he was concerned about the death certificate being available on the public docket, he was welcome to provide the document directly to my chambers to ensure his privacy. I also made clear that, should he fail to provide the requested documentation by August 26th, he would be held in contempt of court and subject to sanctions, including monetary sanctions, and or referral to this court's grievance committee. That's like the disciplinary board or disciplinary council. That's like, you're going to get in trouble now. On August 26th, the day Mr. LIEbowitz was required to provide his grandfather's death certificate pursuant to my August 19th order, Mr. LIEbowitz instead submitted another declaration. In this declaration, Mr. LIEbowitz argued that he was not in contempt because this court's request for his grandfather's death certificate was unlawful, as it likely constitutes an usurpation of judicial authority or a breach of judicial decorum. Oh, he's so screwed. His previous declarations complied with my previous orders, according to him. There was no basis to impose monetary sanctions, and the court's assurance that his grandfather's death certificate would not be made public was insufficient to protect his right to privacy. On September 27th, I endorsed Mr. LIEbowitz's latest declaration, stating that there is nothing unlawful about my August 19th order. There was also nothing unclear about it. Likewise, Mr. LIEbowitz's failure to comply is apparent beyond any reasonable doubt. Finally, he has not diligently attempted to comply. To the contrary, while maintaining that the death occurred and thus implicitly conceding the existence of a death certificate, he has repeatedly refused to provide it even after the court made clear that his good faith declarations were insufficient and after the court agreed that the document need not be publicly filed. He has not shown or even alleged an inability to comply. I therefore declared Mr. LIEbowitz to be in contempt of court and ordered that, should he fail to comply with my previous order and provide the requested documentation by October 2nd, he would be subject to monetary sanctions of $100 each business day until he complied. I also informed Mr. LIEbowitz that, should this sanction prove insufficient to ensure his compliance, additional or different sanctions would be considered. And that's it. And that's how it ends. LIEbowitz eventually complied and everything was great. Turns out his grandfather really did die. Case closed. Case closed. Have a good day, everybody. Thanks for coming. On October 2nd, Mr. LIEbowitz wrote a letter to my chambers requesting an in-person conference to discuss the order and to request a stay of the order for just cause until the conference could be held. I denied this request, noting that Mr. LIEbowitz's letter had not stated what purpose would be served by an in-person conference, nor had it supplied any justification for a stay of my order. Mr. LIEbowitz submitted another letter the next day, October 3rd, reiterating his request for an in-person conference to discuss his grandfather's death certificate and for a stay for just cause. We need to take a break, guys. I'm sorry. We have a situation developing. He's looking at you.
He's become self-aware.
Would you like to come hop for a treat? Oh, he is ready. He is ready to come hop for a treat. Do I go back? Okay. He's just like waiting for the cue. Go lay down, my boy. Here. I'll toss one to you. There you go. Mr. LIEbowitz submitted another letter the next day, October 3rd, reiterating his request for an in-person conference to discuss his grandfather's death certificate and a stay for just cause. I again denied the application because Mr. LIEbowitz had not articulated any purpose that the conference would serve, nor did he supply any cause to stay my order. I further ordered Mr. LIEbowitz to refrain from filing any further requests for a conference unless he could explain specifically what purpose would be served by the conference, and to refrain from filing any further requests for a stay of my order unless he could specifically state his justification, his good cause. You don't just say for good cause, you have to show good cause. I notified Mr. LIEbowitz that his first payment under the contempt sanction was due Monday, October 7th. On October 7th, Mr. LIEbowitz sent a letter requesting a 2-week extension to deliver his grandfather's death certificate and requesting that the monetary sanctions be stayed until after the extension had elapsed. This request had come at 8:34 p.m., well after the clerk's office had closed. That same night, I denied LIEbowitz's request for an extension. As of November 1st, 2019, LIEbowitz has not made any of his required payments. By the court's count, Mr. LIEbowitz was obligated to pay $300 by October 7th, $400 by October 15th, $400 by October 21st, and $500 by October 28th. So wait, let's keep track here. That is 7-11, that is $1,600 so far. So let's see, the LIEbowitz tally is up to $1,600 so far. Richard LIEbowitz, plaintiff's counsel in this case, is now in contempt of my August 19th and September 27th orders. The $100 fine he accrues each business day has plainly been ineffective to coerce compliance with the August 19th order. Accordingly, the daily contempt sanction is hereby increased to $500 per day, effective November 6th. Starting on that date, Mr. LIEbowitz will be sanctioned $500 per business day, payable on Monday of each week or Tuesday if the clerk's office is closed, until he has complied in full with my orders. Further, Mr. LIEbowitz is hereby ordered to appear before this court in person. So he finally got his in-person conference request, eh? On November 13th, I believe that's a Wednesday, November 13th, 2019 at 10 a.m. and there and then show cause why he should not be incarcerated until such time as he complies with the above described orders, and if applicable this order, failure to appear as directed will subject Mr. LIEbowitz to arrest by the United States Marshals Service without further notice. And then she has a little exception paragraph here. Should Mr. LIEbowitz already be committed to appear before another court, he shall notify no later than yesterday. So advise the court by letter and enclose proof of the commitment from a source other than Mr. LIEbowitz. No adjournment will be considered unless it is timely and accompanied by proof, and the letter shall make additional dates available. That is Judge Kathy Siebel, United States District Judge in the Southern District of New York. If you are Richard LIEbowitz, you may want to just eat crow a long time ago, but you can't go back in time, so you might just want to start. You might just want to be like, Judge, I did a bad. I'm sorry. In fact, I'm going to go one step further. If you are Richard LIEbowitz, you should be talking to your defense attorney for what will basically be the inevitable disciplinary action that's going to be coming down the road. So let's just see. This was a couple days ago. We found out about it last night, but that happened a couple days ago. So let's just take a quick look here. Is it possible that there's an update in this case? No, there is no update in the case. He's in the middle of being fined $500 per business day. So when did that start? The $500 per business day started on November 6th. So today's the first day. So he's, as far as I know, not filed anything. So he's up to $2,100 already, and he has to appear next Wednesday or else get arrested. So this is also a great opportunity to talk about the model rules of professional conduct. Now, again, the model rules are not the rules. They are the model rules that the rules then come from. So the American bar writes the model rules. This is Rule 3.3, candor to the tribunal. You can be 100% sure that New York has some version of this rule that looks very much like this and has these duties incorporated. So as an advocate, the lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So what is that? This is one of the coolest models. This is one of the coolest rules of professional conduct ever. This is something that before I became a lawyer, I didn't realize you couldn't do. Lawyers can't lie. I know. You have to pick yourself up off the floor. I know you're laughing. Calm down. Really, though, lawyers can't lie. They're very good at bending the truth, or as you see LIEbowitz, he doesn't want to admit that his either grandfather didn't die or that it didn't happen the way that that he said it did. So he's trying to get away with it while also avoiding lying. If he was allowed to lie, he would just continue to double down and say, oh yeah, here's a fake death certificate, and here's a letter from my grandmother, and here's the obituary in the paper, and but if he does that, then he makes it even worse because of this rule. Second, to fail to disclose to the tribunal legal authority in the controlling jurisdiction known to be directly adverse to the position of the client and not disclosed by opposing counsel. To offer evidence that the lawyer knows to be false. So you can't present false evidence either. There's a couple extra parts here. A lawyer who represents a client in an adjudicative proceeding and who knows that the person intends to engage in criminal or fraudulent conduct shall take reasonable steps, including remedial measures, and if necessary, can disclose the criminal or fraudulent conduct to the tribunal. So your lawyer cannot help you lie is another thing. The duties stated in paragraphs A and B continue even after the conclusion of a proceeding. And then here's one that I think trips up Strike 3 holdings and other BitTorrent lawsuits like we saw with Judge Schneider and Judge Lamberth and hopefully others coming up here. In an ex parte proceeding, which are those expedited discovery, those expedited subpoenas. In an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse. So that means that the lawyer must fully inform the judge when they are ex parte. And lawyers are good at this. We are fiduciaries. We are used to fully informing our clients before asking our client to then make a decision. It's literally our duty to do that. So that duty just applies to the judge now. And it's like the judge is the client and you have to tell the judge everything, including if there are bad things. So we say, I believe, is my professional opinion, that Strike 3 Holdings does not disclose enough to the judges in federal court. And is not in it's not in compliance with their Rule 3.3D requirements. However, I'm not sure that it rises to a level of a disciplinary action. It seems to me it should rise to the level of simply denying their subpoenas. And I haven't seen activity that I believed was unethical enough to warrant disciplinary action against a particular attorney. It's arguable, though. That is the current status of the Richard LIEbowitz story.
The bell tolls for Richard LIEbowitz.
Yeah, listen up, Richard. Attorney LIEbowitz, incarcerated LIEbowitz. Wow, I just really can't believe that this is what it's come to. Is like he's gonna do such a bad job that he gets himself thrown in jail for lying to the judge. I mean, I don't want him to be thrown in jail. Like, I genuinely don't want him to be thrown in jail, but I would die laughing. So that is our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal education and legal news channel on YouTube and sometimes on Twitch, and maybe we'll see where else we go. Thank you for your financial support on patreon.com/ljfrench and sponsors.com/law. This channel and its mission would not be possible without your financial support. Thank you very much to our current supporters at the $50 level in November. Thank you to Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters scrolling on the LED panel behind me and in front of me on the crawl. We'll put some dog or travel B-roll here for your mild entertainment while we outro you. Thank you for joining me again. I'm Leonard French, your favorite copyright attorney. We'll see you in the videos that drop. Have a great weekend. Love you all. Bye. Oh, honey.